Noting everyone's presence back in the courtroom, are we ready to proceed, counsel?
Yes, Your Honor.
Defense is ready, Your Honor.
Please have the jury return to the courtroom. Members of the jury, the defense will now present its closing argument. Mr. Holloman.
Your Honor, it please the court.
Ladies and gentlemen of the jury, I'm not going to stand up here and try to give any justification or any excuse for what you found Michael Bargo guilty of. As a matter of fact, we all agreed, just to the difference in the degree, that it was a homicide. And there's no question about that. The facts, these empirical facts of what they found, it is what it is. That's exactly what it is. And the law is what it is. And what they're asking you to do is this. They're asking you to make that decision about whether or not you're going to make a recommendation to the judge that his life be taken. I'm not here justifying what Michael Bargo did, but before you do that, you need to consider all the factors, particularly the law. The prosecution's arguing this thing like it's like you're asking for a murder conviction. Well, that's already been established, first-degree murder. It's not if they prove these aggravators beyond a reasonable doubt that dictates death, because it does not, all right? As a matter of fact, it says in the jury instructions, it says the sentence that you recommend to the court must be based upon the facts as you find them from the evidence and the law. And then it says if, after weighing, and you'll hear that a lot, the aggravating and mitigating circumstances, you determine that at least one aggravating circumstance is found to exist, and that the mitigating circumstances do not outweigh the aggravating circumstances, or, in the absence of mitigating factors, if there were none, that the aggravating factors alone are sufficient. It says you may, it doesn't say shall. It says you may recommend that a sentence of death be imposed rather than a sentence in life in prison without the possibility of parole. Then it has a very important sentence. It's one that the prosecution does not tell you. It's right here in the jury instructions. Regardless of your findings in this respect, whether there's aggravators or mitigators or what. However, you are neither compelled nor required to recommend a sentence of death. They don't put that on jurors. What they want you to do is they want you to weigh the aggravation and the mitigation. But in the end, in the final analysis, it's right here in the jury instructions, quote, regardless of your findings in this respect, the weighing. However, you are neither compelled nor required to recommend a death sentence. Now, we've had some heated advocacy here over certain points, and I certainly respect, I've known these people for years, they've known me for years. They do a great job. It's a good fight. And the art of advocacy has certain things with it. And we've both got our own spin on this kind of thing, to be real honest with you about it. And they, of course, they're wanting a death penalty. I understand the reasons why they're wanting that. But our take on this thing is different. Look, Kyle Hooper, all these other people, they make like this couldn't have been done without Michael Bargo. And there is absolutely no evidence to that whatsoever. Kyle Hooper ran right outside that door. They chased him down. They dragged him back inside. They're equally culpable. In evidence is certified judgments and convictions of all these other people that got life in prison. I would submit to you this. They pinned this thing, their death penalty recommendation, on the fact that he had the firearm, the fact that he used the firearm. I submit to you there was a killing that would have taken place anyway, even without that. And that does not excuse or justify what he did. It just simply, it does not. But to listen to them talk about Kyle Hooper, all of a sudden Kyle Hooper is the man with a conscience. And it's not. It's not that way. Damn them all, they're all equally responsible. Kyle got up there on that stand, and he gave his testimony, and he told about the plan. He didn't say anything about any guilt pangs or anything else. What you've got is you've got a situation where people they were in this place, they're all using drugs. That does not excuse or justify it, but that is one of the things that's mitigating factors. What it does is this. You're going to spend the rest of your life in prison, at least. One way of wording it is this. You're going to die in prison. It's just a question of when and by what means. You know? That's the issue. And I submit to you this. Even with their own set of facts, they talk about, what is it, anti-authoritarian or stuff like that, wanting to do what he wants to do. That was their story. But let's just try that on for a minute and see how that fits with the sentencing recommendation. We've got a lot of prisons in this state, and he sure ain't going to be the person that's eligible for work release. And I can't think of a better solution to this case than he have to live there for the rest of his life, and he have to take those marching orders and everything else, because he will live there until he dies there. Now, it's very easy in a case like this. Well, it's not easy, but you know, these horrific set of facts. I mean, they tug at the heartstrings. I mean, there's absolutely no, you would have to be inhuman, or in their words, a psychopath, to not feel it. Because of the manner in which this murder took place. But we're different. We're different than the folks that were in Charlie Ely's house. And I think Ms. Barnes said it the best. She said, you know, passions or prejudice or anything like that, or anger, which the judge is going to tell you in the jury instructions, that's not supposed to influence. And it's so easy, you know. I can validate those feelings because it's so easy to feel anger about this. We see too much of it every day, and we see more and more of it. And it's so easy to want to lash out with a verdict because of that. He was only 18 years old at the time of this thing. That is a mitigating factor if you want to get into the weighing thing, okay? But it's like I say, no one individual is ever required to bring back a death penalty in the state of Florida, and that's part of the Florida law. Cold, calculated. It's an absolute parade of horrors. I mean, there's no question about it. Then they want to talk about this dominion and control. Look, that begs the question. It's very obvious that Michael Bargo wasn't acting under the dominion or control of anyone. I do think it's a little bit vague as to exactly whether he was the so-called leader of the pack, because Kyle Hooper had his difficulties with him too. Of course, you heard a little bit about a pang of conscience that Kyle Hooper had. I don't know whether that really happened or not, but I know one thing. It's almost like they want to pin the Medal of Honor on him. How big was he? He's lost 30 pounds since he's been in jail. He's up to around 200 pounds. Little old Michael Bargo. Kyle Hooper could have stopped this thing, and then he would have been a hero. But you see, the thing about it is nobody is a hero that was involved in this thing at all. Not a single person. Now, in regard to the mental aspect of this case, let's take a look at this thing. Dr. Berlin. You remember him, the guy with the MMPI, all right? He explained how that worked, or at least how he thought it worked, until Dr. Pritchard put in his 2 cents, and he came up with a profile based on a test that's been around since 1938. He works for the state. The state uses this test. We use it in mental institutions. We use it in evaluating, as he said, the competency of clients. So what's wrong with that? Dr. Pritchard, if there's something wrong with this test, you told us. You've administered thousands of them. Thousands of them. Why didn't you do it? Why didn't you do it? If you're going to complain about the house the way it's built, show us how to build one. Show us how it's done right. Reading it to them versus letting them read it. He didn't quote any authoritative treatises. That's okay, because if you're going to do that, then you show us how it's done right. You come up with a valid profile. No, he decides to use a questionnaire, a checklist, as he calls it. The book, it's really interesting, because the book that's laying beside Dr. Berland was the MMPI book, okay? But the book that's laying beside Dr. Pritchard is DMS-3, and that is because he is a behavioralist. And there's different disciplines, there's different modalities of thought of this. He is not an MD. That's one thing. Testifies as an expert in several states, I believe he testified to. He's not board certified. He's not a fellow or a diplomate or anything like that. He's never published, he's never written articles or anything. But he's not a medical doctor. And that means the PET scan. What about the PET scan? What about the efficacy of that as to having a mental problem? Well, he can't comment on the PET scan because he's not qualified. See, the difference in this case is this, and there's a battle between, apparently, it's the behavioralist and the people that would think that there was a neurological basis for these problems. Of course, the 2 sides aren't meeting because they didn't call an MD. They did not call an MD. They did not get someone that was conversant with PET scans to counter this. So what happens is this, the PET scan stands unrefuted. And there are obviously behavioral problems here. I mean, there can't be any question about it. The dearth of this stuff. I mean, the pages and pages and pages. The way this crime was committed. And what's the state's answer? Well, he's just got a bad attitude. Well, I'll give him that and much more. And you've seen an organic basis for this. You've seen the science of it. And all you've heard is her cross-examination from a list of questions that are just typical, that they always ask about that. But you haven't seen any real impeachment. Now, do I say this by way of justification for what happened? And I have to always come back to that, okay? That's no justification for what happened. It's not. He should still have life in prison till he dies there. But that is what mitigation's all about. Now, what about the parents? It's difficult to tell where the truth lies between them. Here we've got their son on trial for murder, facing the death penalty. What are they doing? What does she say? Fight to the death. It's all your fault. And that's all they've done. That's all they've done is point at each other. Now, does that justify what Mike did? No, it doesn't justify it. But it shows that, you know something, the law, it makes certain rules. That's why we have mitigation. For people that didn't get a fair shake out of life. That does not mean that it excuses things. Because what we're talking about here, in reality, is the issue of whether we're going to throw the rope over the tree, so to speak. And it is so easy, you know it is, in a case like this, to have those kind of feelings. And the type of jury, we talked about this in voir dire, is you want a jury of people that, well, we got emotions, all of us do, but they can keep it in check somewhat. Because what happens if we run away with our emotions, and we could in a case like this? I'm with you, okay? And do the rope over a tree thing, you know something? If we based it on that we were pissed off, because we are, you know, you gotta be, you wouldn't be human if you weren't, but if you can't keep that in check and you do that, it's almost no better than that group of people out there at the house. So that's why we try so carefully to pick a jury. Did he recognize the value of human life? Hell no. When that happened, how can you say that? Because he didn't. But we are made of sterner stuff. And while we've got a death penalty, I would hope we'd be very judicious in the application of it. There's mitigating factors. What is a mitigating factor? Well, there's what they call non-statutory mitigating factors. And it's just about, in reality, it's just about anything you would want it to be. I mean, there's some that could be But I think really more it comes from the understanding of this case. For example, they have certain mitigators in this case. If you find Kyle Hooper participated in the killing of Seth Jackson, then you may consider this a mitigating factor. Well, you may. If you find Michael Bargo was less or equally culpable than the other participants, then you may consider that a mitigating factor. And we go down, we have this like boot camp. What is this? What this does is, all this is a rehash of the facts of the case in much the same fashion as the state. It's just the flip side of it. I just put that up there because I was able to just generate 59 of them off the top of my head. Well, what am I going to do? Am I going to read all those 59 to you like it's some sort of principle of law? No, I'm not, because it's what it is that mitigation it kind of comes from a different part of your heart or your brain. It's to be able to look at something like this and say, is it mercy? Well, I don't know. It might not be mercy. You know, you might go the other way. Can you imagine how the rest of his life you vote that way, to think about what the devil did, to think about the lives that were destroyed. Because it was more than just the victim here. And the victim lost his life. It's the families. It's everybody. It's everybody that fell under that influence. It's everybody that agreed to that. And these people, these other people that were there, they were old enough. They knew what they were doing. They joined into it. Like I said, that's not an excuse. Damn them all. But that's not an excuse. What it does is, it doesn't rise to the level of saying that we should execute it. Because of these difficulties that he's had to face in his life. Now, there, if you got involved with the Sarah Quill thing, it is, it isn't, there are papers, documents in our submissions that show school records. You know what? And what it is this. You know, it's like the old expression. How does it go? Nobody's going to do something until something happens. Even when the warning signs are all there. I'm not blaming anybody else. He's responsible for that. We've already found that legally. But it just struck me as odd. I was reading this report from 2007. It's an evidence. You know, in light of his history of self-injurious behavior and violence toward others, the probability of continued violence is especially high. How prophetic. That was in 2007. We had episodes where he tried to kill himself, episodes where he was a cutter, that bizarre thing where his mom described he ran out in the street or ran around in the house one night, laid down in the middle of the road, stuff like that. Yet the state would paint with a broad brush and say, well, he's normal. Well, no, they don't, because they contradict themselves. Because, hey, look, what was the first thing out of their mouth as they pointed back at him? He is a psychopath. And that's an illness. He ain't normal, as they say. And that's one of the reasons why we'd ask simply that his life be spared in this situation. He had this involvement with social services left and right. Dr. Farmer, Dr. Finn, they even opined that he needed long-term inpatient care. We just didn't just generate all these records out of the clear blue sky, or this divorce or anything like that, or the drama, you know, that came along with that. Because he was certainly more than a troubled child and a troubled young adult. And I'll give both of us credit. If we knew what the problem was, we probably wouldn't be here, because it's a problem that always plagues. These things are difficult. They're difficult in terms of diagnosis. Dr. Berlin opines that he was misdiagnosed because, I'm sorry, Dr. Wu. Dr. Wu was the one that originally said that. He was misdiagnosed because he had evidence, which he shared with you, that the PET scan showed the abnormal brain activity in the right occipital lobe. And he told you exactly what that influences. It's like I said, the science has been around, it's been developing for 38 years. And we know for a fact that when that happens in that area of the brain, it has certain manifestations. It will manifest itself psychologically in certain abnormal behavior. And he described that behavior to you, the paranoia, the schizophrenia, everything like that. While at the same time, Dr. Berlin is running his MMPI, and he's achieving results that shows that. And the MMPI was run long before the PET scan was. So you've got a real good cross-check on that. Now, maybe I won't say that. That'd be too cutting. Look, they're asking you to kill him. That's what it is. Make a recommendation. The judge has to give you a recommendation. Great weight. Great weight. Okay? But if you're going to do that, look. If you're going to war, you don't go to Walmart and buy your ammunition and your swords and things like that. Okay? You refute these things. You refute the PET scan. And you do more than refuting it than coming up with a bunch of canned questions about it. You call experts. There's many experts all over this nation. And obviously you're able to guess. Dr. Wu is one of the most renowned experts in the United States. He's testified all over the United States. Does the university he's with, did they get paid for it? Yeah, that's right. But also another thing that's the stock and trade of attorneys, and I'd do it myself. Do it myself when the moment's right, is I'll talk about somebody getting paid. Because it's part of impeaching them. It's part of undermining their testimony. The real question is this, ask yourself honestly, do you think somebody with those kind of credentials is going to come in here and make up a lie and show a false PET scan? And if they did, how easy would it be for the state to detect that? The answer to that is obvious. And did they refute that? No, they did not refute that. All they basically did was use what I refer to as the Wizard of Oz defense. Ignore that man behind the curtain, is what they did. Because what that shows is this. It shows clearly that there is an organic basis, there's a neurological basis for what he experienced. Now, they got involved with bumps on the head, and they've been obsessed with bumps on the head. They made it clear throughout our investigation and throughout the preparation of this trial, it can come from several ways. Number one, it can come from chemical dependency drug abuse. Damage can be done. Number two, it can be a hereditary trait. What evidence do we have of hereditary traits? Grandfather. Grandfather was a mental case. Okay. And father, you had a chance to see him testify. He didn't Ozzy and Harriet, that's for sure. Maybe Ozzy Osbourne or something like that. But it just isn't. There is a history of mental disturbances in this family. One of the things that's been so frustrating is how can the state ignore that and pretend it doesn't exist? It's of great weight. It's of great moment. Because look at this killing. Look at the manner of it. Okay, you want to buy into the fact, which obviously you have to get a first-degree murder conviction, that Mr. Bargo orchestrated this thing, okay, or something like that, because they presented evidence of that, their own evidence. What kind of psychopathic nut would you have to be mentally deranged to do that to somebody? The manner of the killing is crazy as hell. And then you take that and you lay this on top of this thing of all this psychological data, all these tests that were run, all this material that was given to you, everything that you're going to have in evidence to be able to look at. And we had and there's several things on these boards here, but you're going to have that back in there with you. You know, we're going to mount them, but you know, we'd keep you here all day. You know, I want to speak from the heart here and tell you what this case is about, what it means. It means you've got a troubled kid or a young adult now, and he's done unspeakable acts. And the only reason, it's not him getting a quote break, because you might think that. The only break he should get is die in state prison. at the normal end of his life. The capacity of Mr. Bargo to govern his actions in accordance with the law and conform his conduct to the requirements of the law, it's impaired. And it's impaired because it's a mental case. Now, I can't tell you because I'm not an expert of what that diagnosis is, and we respectfully, both of us, we have our disagreement on that. But it's very obvious something is wrong. And it's not too hard to see where it comes from. It's hereditary. Now, there was nothing like this before this. I mean, was there something where, like something that would give you a warning, maybe some heinous act done in kindergarten or as he was getting older or something like that when this problem developed? There wasn't any action that would give us an alert as to this. All of a sudden, there was just this explosion when this thing happened. But he'd always had those anger management problems. He'd always had those difficulties. You heard of all the different medications he was on. They were all psychotropic medications, most of them. They want to debate about Seroquel versus 400 milligrams versus 50 milligrams. Well, how many milligrams are used for sleep, Doc? Well, gee, I don't know. But you know something? As I've shown you, Mr. Holloman, just because I don't know the answer doesn't mean I won't have one. Seroquel's in those records. A bunch of other things are in those records. There's direct evidence of it, but it's almost like the circumstances. It's almost like circumstantial evidence in a way, because it comes from the circumstances, but the circumstances are pretty direct with the testimony and the various medications and stuff, that there is serious problems. How can they say, how can they say that he's normal and does something like this?
Counsel, you have 15 minutes remaining.
Thank you, Judge. Then they talk about Mr. Bargo's character, Mike's character. They say there's nothing in his character that ought to weigh. What are we talking? That's generalities. His character? I didn't hear much about his character. I heard more about his aberrant behavior, to put it mildly. Where's that photograph? I wasn't even going to show this, but she promised I'd wave it in front of the jury, so I will. This is not for sympathy, because you're not supposed to make a verdict based on sympathy. He might have had some character then. He was a young kid. He was just like any kid does. Cute little boy. You can bet his mama loves him. His mama loves him now. And the last thing that his mama would ever want was to go out and be a murderer. But that's what he is. We've already determined that as a matter of law. So, what it comes down to is it's not really compassion, but it's something similar to that. It's like that. It's not an insult to the victim. I mean, the killing of Michael Bargo Jr. will not bring back Seth Jackson. Because if it would, I imagine the vote would be probably unanimous. And there's not really much more you can say on that. But I just ask you to go back there and just do this. If you do this, you're going to do the right thing. If you do this, you're going to do the right thing. Just go back there, have a good rein on your emotions, and consider this thing without getting angry. And it's so hard not to get angry. I know that, and I appreciate that. I've watched the jury very closely during the trial, and I know that, you know, there are times when I could feel that. I could feel it. I could feel it myself. You know, I look at these facts, but, you know, when they come across our desk, you know, and deal with these types of cases sometimes. But this is a tough one. That's pretty much it. So what I'd like to ask you to do is go back there and carefully consider this thing and bring back a recommendation to the judge that Mr. Bargo serve the rest of his life in prison. Thank you.
Could we have those materials repositioned, please?
Sorry, Judge?
I just want those materials repositioned in the courtroom.
Do you want to reposition the podium?
That's fine. You're fine. Ladies and gentlemen of the jury, you will have this set of jury instructions delivered to you in the jury room for your review if necessary during your deliberations. But please listen carefully to me as I read them to you. It is now your duty to advise the court as to the punishment that should be imposed upon the defendant for the crime of first-degree murder. You must follow the law that will now be given to you and render an advisory sentence based upon your determination as to whether sufficient aggravating circumstances exist to justify the imposition of the death penalty, or whether sufficient mitigating circumstances exist that outweigh any aggravating circumstances found to exist. The definition of aggravating and mitigating circumstances will be given to you in a few moments. As you have been told, the final decision as to which punishment shall be imposed is the responsibility of the judge. In this case, as the trial judge, that responsibility will fall on me. However, the law requires you to render an advisory sentence as to which punishment should be imposed: life imprisonment without the possibility of parole, or the death penalty. Although the recommendation of the jury as to the penalty is advisory in nature and is not binding, the jury recommendation must be given great weight and deference by the court in determining which punishment to impose. Your advisory sentence should be based upon the evidence of aggravating and mitigating circumstances that you have heard while trying the guilt or innocence of the defendant, and the evidence that has been presented to you in these proceedings. It is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, did the witness's testimony agree with the other testimony and other evidence in the case? 6, had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 9, was it proved that the witness had been convicted of a felony or a crime involving dishonesty? 10, was it proved that the general reputation of the witness for telling the truth and being honest was bad? You may rely upon your own conclusion about a witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to the consideration of his testimony that you apply to the testimony of other witnesses. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful recommendation. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your recommendation will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. Your recommendation must be decided only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits in evidence, and these instructions. 3. Your recommendation must not be based on the fact that you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your recommendation. 5. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. 6. Your recommendation should not be influenced by feelings of prejudice or by racial or ethnic bias or by sympathy. Your recommendation must be based on the evidence and on the law contained in these instructions. An aggravating circumstance is a standard to guide the jury in making the choice between the alternative recommendations of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance which increases the gravity of a crime or the harm to a victim. An aggravating circumstances must be proven beyond a reasonable doubt before it may be considered by you in arriving at your recommendation. In order to consider the death penalty as a possible penalty, you must determine that at least one aggravating circumstance has been proven. The state has the burden to prove each aggravating circumstance beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating circumstance if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating circumstance exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating circumstance has not been proved beyond every reasonable doubt, and you must not consider it in rendering an advisory sentence to the court. It is to the evidence introduced during the guilt phase of this trial and in this proceeding, the penalty phase, and to it alone that you are to look for that proof. A reasonable doubt as to the existence of an aggravating circumstance may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating circumstance, you should find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating circumstance does exist and give it whatever weight you determine it should receive. The aggravating circumstances that you may consider are limited to any of the following that you find are established by the evidence. 1. The capital felony was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means it's designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. The kind of crime intended to be included as heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to the victim. 2. The capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means the defendant had a careful plan or prearranged design to commit the murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating circumstance to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of homicide, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. If you find the aggravating circumstances do not justify the death penalty, your advisory sentence should be one of life imprisonment without possibility of parole. Should you find sufficient aggravating circumstances do exist to justify recommending the imposition of the death penalty, it will then be your duty to determine whether the mitigating circumstances outweigh the aggravating circumstances that you find to exist. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything in the life of the defendant which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstances may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proved by the greater weight of the evidence, which means evidence that is more likely than not tends to prove the existence of a mitigating circumstance. If you find by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence imposed. Among the mitigating circumstances you may consider are: 1, the capital felony was committed while he was under the influence of extreme mental or emotional disturbance. 2, the defendant acted under extreme duress or under the substantial domination of another person. 3, the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. 4, the age of the defendant at the time of the crime. 5, the existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense. If one or more aggravating circumstances are established, you should consider all the evidence tending to establish one or more mitigating circumstances and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence that should be imposed. The sentence that you recommend to the court must be based upon the facts as you find them from the evidence and the law. If, after weighing the aggravating and mitigating circumstances, you determine that at least one aggravating circumstance is found to exist and the mitigating circumstances do not outweigh the aggravating circumstances, or, in the absence of mitigating factors, that the aggravating factors alone are sufficient, you may recommend that a sentence of death be imposed rather than a sentence of life in prison without the possibility of parole. Regardless of your findings in this respect, however, you are neither compelled nor required to recommend a sentence of death. If, on the other hand, you determine that no aggravating circumstances are found to exist, or that the mitigating circumstances outweigh the aggravating circumstances, or, in the absence of mitigating factors, that the aggravating factors alone are not sufficient, you must recommend imposition of a sentence of life in prison without the possibility of parole rather than a sentence of death. The process of weighing aggravating and mitigating factors to determine the proper punishment is not a mechanical process. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. If you find there was more than one co-defendant and that Michael Shane Bargo Jr. did not act alone in the killing of Seth Jackson, then you should consider the relative culpability of each co-defendant. If you find they were equally culpable in the death of Seth Jackson, then Michael Shane Bargo Jr. should be treated alike in sentencing and receive equal punishment. In these proceedings, it is not necessary that the advisory sentence of the jury be unanimous. The fact that the jury can recommend a sentence of life imprisonment, or death in this case, on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you ballot, you should carefully weigh, sift, and consider the evidence, realizing that human life is at stake, and bring your best judgment to bear in reaching your advisory sentence. If a majority of the jury, 7 or more, determine that Michael Shane Bargo Jr. should be sentenced to death, your advisory sentence will be a majority of the jury by a vote of blank to blank, and you will actually fill in that numerical division, advise and recommend to the court that it impose the death penalty upon Michael Shane Bargo Jr. On the other hand, if by 6 or more votes the jury determines that Michael Shane Bargo Jr. should not be sentenced to death, your advisory sentence will be: the jury advises and recommends to the court that it impose a sentence of life imprisonment upon Michael Shane Bargo Jr. without possibility of parole. When you have reached an advisory sentence in conformity with these instructions, that form of recommendation should be signed by your foreperson, dated with today's date, and returned to the court. There is no set time for a jury to reach a verdict. Sometimes it only takes a few minutes. Other times it takes hours or even days. It all depends upon the complexity of the case, the issues involved, and the makeup of the individual jury. You should take sufficient time to fairly discuss the evidence and arrive at a well-reasoned recommendation. Ladies and gentlemen, you will have 2 forms of advisory sentence, only one of which should be filled out, and only one of which requires that numerical division to be placed on the advisory sentence. Members of the jury, to be presented to the jury room during your deliberations will be the exhibits which have been received in evidence, these jury instructions, and the advisory sentence forms, again, only one of which shall be filled out. Members of the jury, you will now retire to consider your recommendation as to the penalty to be imposed upon the defendant. You should take your notepads with you. Noting that the jury has retired from the courtroom, counsel approach the bench. We'll just, number 1, check the exhibits, make sure all exhibits are received in evidence, and this doesn't need to be on the record. If the recommendation is for a death penalty, I'm going to automatically have the jury polled. If it's for a life sentence, do you want the jury? I will simply ask the foreperson to confirm that recommendation. So again, death penalty recommendation, clerk will poll each individual juror. If you'll check the exhibits. There's a standard polling. You can, yes it should. I'm going to instruct them to consider all the evidence in both phases. They can. Let's go back on the record. Counsel, I want to commend each of you for the professional manner in which this trial was conducted. I greatly appreciate as the trial court judge. Thank you for your professionalism addressing the audience. Obviously no one will know what the jury will do. No one can predict with any certainty a jury's advisory sentence. I do expect everyone to maintain their composure in the courtroom. Whatever advisory sentence is returned, sentencing will not be conducted today. A sentencing hearing will be set at a later date. It will be in recess until the jury either has a verdict, or an advisory sentence, or has a question.
You could actually be here by another week. They